Migration Conversations is a podcast that invites persons to share their migration stories. Hosted by myself, Professor Jamie Liu, each episode is an in-depth conversation with people who have experienced the Canadian immigration system or other migration regimes up close. We talk to migrants, immigrants, lawyers, policymakers, advocates, and experts. We hope that these conversations shed light on the challenges migrants face through their own voices. Welcome back, everyone, to Migration Conversations. This week, we are talking about the economic class in Canada. And for this episode, I'm joined by University of Ottawa common law alumni and Ottawa immigration lawyer, Jacqueline Bonisteel. Jackie is an expert on the economic class, and I'm so grateful she's willing to share her experience with us. Jackie, I wanted to begin by asking you how you became interested in immigration law, what advice you have for students wanting to pursue this area of law.
Sure. Thanks, Jamie. Thanks for having me. How I became interested in immigration law is sort of a roundabout path for me. I came to law school. I did the joint program with NIPSIA, so the Master's in International Affairs and Law School. And my intent at the time of starting was not to practice at all, but to sort of have an international law-esque career of some sort. But I was surprised by law school. I liked it more than I expected to. I liked the actual, reading case law and being on my feet aspect of things, and working with clients in particular. That became a big thing for me. I realized I maybe didn't want to be a policy wonk and maybe wanted to actually have real people with real immediate problems who I was dealing with regularly. So, but the refugee law classes that I took in law school, I realized quickly that had the international component that I was really interested in, and the working with people component. So it started for me with refugee law, which I think is the case for a lot of law students, because that's a lot of the content that we get in law school, which I think is fantastic, particularly at U of O. There's such an amazing refugee law program. And yeah, so I started taking classes in that area, and then was able to work at the legal clinic with the refugee lawyers there. And just wanted to get my foot in the door however I could. So I ended up articling at a firm with an immigration lawyer, and working with him. And that's what sort of introduced me to the other aspects, the non-refugee aspects of immigration law, and realized I quite liked those parts of it too. So as I think is the case for a lot of people in this field, a bit of a roundabout path to where I ended up, but I'm really happy with where I am now. I still do some refugee humanitarian work, but the bread and butter of my practice is more standard economic immigration law, and temporary resident applications, work permits, that sort of thing. And I really like all of it. So, in terms of advice for anyone who wants to practice in this area, I'd say use the opportunities that you have now in law school to get some experience under your belt to find out if it really is for you. Take all the classes. If there's an opportunity to get involved with things like the clinic or Carl and the various clubs and advocacy groups that are working in this area, I think it'll help you, one, decide if it's for you, and also you'll have some of that on your resume. And I know at my firm, that's what we're looking for, is any kind of experience. Doesn't necessarily have to be in the corporate area, but some indication that there is an interest a real interest in refugee and immigration law is always something that sort of makes a resume pop out to us when we're looking to hire. So, yeah.
That's great advice, Jackie. Thank you for that. Shifting gears, we were talking about the economic class today, and I think both you and I agree that this area of immigration law has undergone immense and rapid change over the years. I wondered if you could talk about first of all, the sources of information that you rely on to keep abreast of all the program changes, and how this area of immigration law is different from the others, which you mentioned as refugee law, but also could be, assisting persons through the family class.
Mm-hmm. Yeah, it's I laugh with that question because that's sort of one of the first major things that I needed to learn. I think in law school we're taught rightly to look to the legislation and the regulations and the case law for background on how an area of law works. And if you do that with economic immigration, you will you'll be in trouble because a lot of the information just isn't available through those sources. I still think it's the best starting point, particularly when you're at the student stage just starting to learn about these programs. You need to know the act, you need to know the regs, you need to know some of the basic jurisprudence. There's not a lot in the economic world, but beyond that, a lot of the changes to these programs happen through things like program delivery instructions. Right now during COVID, there is, changes every week that are happening through orders in council. So you need to know where to find those. Honestly, my starting point when I'm dealing with a program I'm not familiar with or one that I haven't worked with for a while is Google, look at the IRCC website for the basic descriptions that they have up there, for your layperson, and then dig down from there into things like, the program delivery instructions and the various regulations. But it can be tricky, so for future reference, for anyone practicing in this area, I think it's really, really important to be heavily involved in the bar, to be talking to your colleagues, to be on the listservs that exist for the economic side, it's through the Canadian Bar Association, has an amazing listserv where these updates get shared, and you really do need to keep on top of all the changes because they change all the time, and you need to stay up to date, which is challenging to do. So I think that's one big way that this area of law is different from others. I guess, I don't know, there's a lot of different ways. But I think that's it, is the constant change in this area of law, and also the way that it's politicized. These programs shift as the governments shift. They shift as, stories come out in the media about problems with the programs. And it's often rapid change that isn't always super well thought through. So then they have to backtrack. So, I haven't been doing this too long, but in the time I have been, there's been just massive change. And we do this every year, Jamie. I usually come in to do the lecture on this program, and I have to update my slides every year. Yeah, lots of change.
Thank you, Jackie. Yeah, I agree with you. It is an immense task to practice in this area. I think it's common to be a lawyer to understand that you continually have to re-educate yourself and keep on top of things. The law is a very fluid and flexible and changing world. And so to become a lawyer is to be continually researching, continually learning. And it's no different in immigration law, but perhaps more heightened and frantic and hectic in the immigration context when it comes to the economic classes. And I think, it's interesting that many of the program changes are done through these various methods that don't rely on parliamentary scrutiny. So it's an interesting aspect for, students and listeners to contemplate on, to what extent are programs being vetted or scrutinized or criticized by members of parliament or the mechanisms in our legislatures that review legislation and regulation. So it's an interesting topic, probably beyond the scope of our discussion today.
Yeah, it's an important point, though. It's a common criticism of these changes, and I think it's a valid one because, yeah, a lot of these changes that are made have massive impacts on various communities, and they're not always being carefully scrutinized before they come out. So,
yeah. So let's dive deeper into what the various programs in the economic class are. And Jackie, I wondered if you could give us a brief overview of the various pathways to permanent residence in the economic class, beginning with what the program is. What are the policy rationales? How are people selected? Maybe you can start with the Federal Skilled Worker Program. What is it? How are people selected through this program?
Yeah, that's a good one to start with because it's sort of the original program, and I think we'll go through the others from there, and a lot of the newer programs are designed to address deficiencies with that sort of original Federal Skilled Worker Program. So with that one, I think the original intent was to attract overseas potential immigrants to Canada who had a particular set of education, experience and skills, and language ability. So the program was designed and intended to attract people to Canada who are going to integrate well here economically, who are going to be able to contribute to the economy and raise their families here and stay permanently. So there's sort of two steps to the Federal Skilled Worker Program. The first is determining if you meet the basic eligibility criteria for the program, which are quite simple. You need to have at least a secondary education. You need to meet minimum scores on a language test. And for all these programs, the way that language is measured is you need to take one of three tests. There's 2 English tests available and 1 French test. And those tests are international. There's sites all over the world where you can go in and they test 4 different language abilities: reading, speaking, writing, and what am I missing? Listening. And it spits out a standard score for you, and you need to meet a minimum level to qualify for each of these programs. So language ability, high school education, and then the third sort of threshold eligibility criteria is 1 year of skilled work experience. And the way that skilled work experience is determined, Canada has a system called the National Occupation Classification System that basically anything that you could do for work in Canada is classified into different job categories. So to qualify as skilled work experience, you need to fit into category O, A, or B. Category O is typically sort of managerial occupations where you're supervising other people. Category A is professionals, your doctors, lawyers, engineers. And category B is sort of more skilled laborers, trades and such, usually where you need to have taken some kind of college education or apprenticeship training to qualify. So sort of the common thing is that there needs to be some level of education or experience for it to qualify as skilled work. So, and then it needs to be at least 1 year full-time work experience. So those are the basic threshold criteria, but just having those is not enough. You then move on to a point system. And there's 6 different factors that Canada will look at and assign points for. So the first one is language, and that's the most important one. You get the most points for language. And again, it comes back to your scores on one of these standardized language tests. So you need to meet the minimum threshold, but then your actual scores matter for the points that you get under this grid. Next is level of education. So even though high school is the minimum, typically to meet the points threshold, you're going to need a little bit more. College, you get sort of maximum points for having a PhD, and then it goes down from there. Your level of work experience matters. So if you have 5 years, you're going to get more points than if you have just the 1 year of skilled experience. Age is the fourth criteria. Basically, if you're in your 20s, you're getting maximum points for age, and then it goes down from there. Having a job offer, so arranged employment in Canada, is the fifth factor that gets you points. And then the sixth is adaptability, and there's several different potential ways to get points for adaptability. Having family members in Canada, if you're coming with a spouse who has education or work experience, if you have past experience studying in Canada, for example, those will all get you points under adaptability. So the maximum number of points under this federal skilled worker grid is 100, and if you have a point score of 67 or higher, that's considered a passing grade, and you qualify to apply for the program. Now, I think we might talk a bit later, Jamie, about the express entry system. So it may not be enough these days, even if you meet those criteria to actually come under that program, but maybe we can chat about that when we chat about express entry.
Thank you, Jackie. You described the program in with such ease. It's such a complicated area of law that it's important to understand there's so many different elements and aspects to navigating your clients through it. I wondered if you could now move to the Canadian Experience class. What is this pathway and how do people access it?
Yeah, so as I said before, these other programs we'll talk about are all largely designed to address recognized issues with the federal skilled worker program. So the Canadian Experience class, I think it was 2008 that it came into play. And what the government was recognizing was that the federal skilled worker program wasn't doing a good job of keeping people in Canada who were already here. So, your foreign students who come and get a university education in Canada and then get a job offer afterwards. Those are candidates who have a really great chance of integrating well into Canada because they already have some experience here. But they were being forced to apply through the federal skilled worker program. And a problem at that time was that it was taking years and years to process. So these young people were finishing their education. They maybe had a 1 year or 2 year work permit, but they were still waiting on permanent residence. So they were forced to go back home. And, once people are back in their familiar environment, maybe they meet a partner or they get a new job and we lose them. They don't end up going through with their permanent residence here. So the Canadian Experience class was designed as a way to get students here, students who then qualified for a work permit in Canada, to get them to stay and to have the process move faster. So it used to be that the processing time for CEC was significantly better than federal skilled worker. That's since changed, but that's sort of the original design of the program. So the basic requirements for this one are 1 year of skilled work experience, but the difference is that needs to be Canadian work experience. So you need to qualify 1 year of work experience in Canada with a Canadian employer in a skilled position. And then the other one is the language threshold. The basic language requirement is the same under federal skilled worker and under CEC. And that's it. There's no points grid to meet the basic qualifying criteria for the CEC. It's that 1 year of work experience and language. And that used to be enough to get you in. As I say, express entry has shifted things there, but we can talk about that more.
Thank you, Jackie. And aside from those two pathways, there's also something called the business class, which has two streams, the startup visa and the self-employed persons. Can you give us a brief overview of these?
Mm-hmm. So I think first thing to say about the business class is that it's a shadow of its former self. This used to be a really robust program. There were actually immigration lawyers who focused only on entrepreneur and investor applications and made an excellent living just doing that. But it was actually the Harper government that really changed this. And the big reason for the change was some research and recognition that people who were coming as investors were not staying. I think a pretty common scenario would be, an overseas investor with lots of money makes an application under this program, gets in, parks their spouse and children in Canada so that the children can get a great Canadian education, and they go back to their business and life abroad. And there was one study that showed that Filipina caregivers were actually paying significantly more tax than these incredibly wealthy investors that were coming under this program. So there's a lot of criticism of the business classes, and the Harper government eliminated them completely, and they've never really been reinstated. So the ones that continue to exist are really limited programs. There's a very small number of people who come under these every year. The startup visa, this was one designed a few years ago as Canada's attempt to sort of attract your Silicon Valley type businesses to Canada, and it was actually advertised that way. There were signs up all throughout Silicon Valley advertising this wonderful program to get people to come to Canada. It has not had its desired intent. So the requirement is that you have some kind of investor, a business incubator in Canada support your business. So like your angel investor, venture capitalist firm, you need to get one of those on board to support you. And the requirements for that, I won't get into tons of detail about it, but it's just really tough to meet the qualifying criteria. So I've actually never filed one of these. I've had lots of clients approach me about them, and then we end up going with a different category. If they qualify under one of the economic classes like the Federal Skilled Worker Program, we would pick that because it's just a simpler path. Or sometimes it's a matter of getting them a temporary work permit as an entrepreneur and then transferring them to PR through the Canadian experience class. So usually there's a better path than the startup visa, but anyway, it's a program that exists, and some businesses are coming in through it, so they've kept it around. And same thing with this self-employed category. It's very limited. It's, farming and sort of cultural figures. So the types of candidates that qualify under this self-employed category are very limited to athletes and artists and farming workers. So again, it's really limited. It has a very high processing time. So it's a type of program that we're only using when we absolutely need to. One thing to say though is that there are entrepreneur type programs that continue to exist, but they're through the provinces these days. So a lot of economic immigration has moved to the provincial programs. So every province, territory in Canada has the ability to design its own programs to attract immigrants to the province that specifically work in industries that are needed there. In Ontario, we have programs to keep master's students here after they've completed a master's in Ontario, for example. And so most of the programs have some form of an entrepreneur program that if you're going to be setting up a business in the province of destination that's going to employ people there and bring some money into the local economy, there's programs designed to allow that. So I think when we talk about the business immigration streams, it's largely on the provincial side these days.
Yeah, I think it's really important that you pointed that out, because I think some people forget that immigration is not just a federal jurisdiction purely, and that the
Mhm.
Constitution has given some powers to the provinces to engage in immigration programming to some extent.
Yeah.
Um, Thank you, Jackie. So I wanted to move on to the Caregiver Program. This program has received a lot of attention in recent years, mainly due to the opportunities of exploitation and abuse that can occur, but also because of the needs. You and I both have young children, so we understand the needs related to young children, but a lot of people in Canada also have um, relatives or members of their family that have high medical needs that may need the assistance of a caregiver. There isn't really a caregiver program alive right now, from what I
Yeah.
understand. There were two pilot programs, one that targeted children, as I mentioned, and the other that targeted persons with high medical needs. But I wondered if you could talk about what the caregiver program was, the pilot programs, how you've seen it shift, and what you expect, or if you can speculate what the government's going to do in the future with regards to this aspect of the economic class. It has been a long-standing program, and I wonder what direction the government's going to go with regards to this program.
Yeah, we'll talk about a program with massive change in the last decade or so. So when I started practicing, it was the live-in caregiver program, which was a very long-standing program. So the way that someone would apply to that is it started with a work permit. So the potential employer in Canada would submit an application for what's called a labor market impact assessment to Service Canada, and prove that they sort of tested the market. They couldn't find a caregiver locally, so they needed to go with someone abroad. And often, recruitment agencies were very heavily involved in this process, and a large number of people coming from the Philippines this way. So the identified caregiver would come to Canada specifically to work with one employer who had supported this application for their work permit. And they would have a temporary work permit. They wouldn't be able to bring their families here, so often long periods of family separation for the caregivers who are coming to Canada. And then eventually there was this permanent residence program to transition to permanent residence, but it took an extremely long time. Not everybody would qualify. I think a big problem was the fact that that work permit was tied to one employer. So if anything went south with that employer, if they, financial situation changed and they can't keep them for the full term that they'd planned to, that caregiver is out of luck and they're stuck in Canada without the ability to work. It was not easy to transfer to a new employer, not impossible. So if you were able to find a new employer to support you for a new labor market impact assessment, it was potentially possible to switch employers and get the work experience you needed to qualify for permanent residence. But a lot of people ending up in limbo without status in Canada. And then also just the susceptibility to abuse, because you're stuck with that one employer, and that one employer is your ticket to permanent residence. So if they're nasty and not treating you right and having you do things you're not supposed to be doing in your employment, there was very little power in the hands of the caregivers. So really big problems. And there was some media attention and research directed at that area that I think got the government thinking about how do we change this. And several changes have been made over the years, but I'll move to what the program looks like now. So last year, 2019, they introduced these two pathways, and this program is now billed as a way to a new program that prevents abuse for several reasons. One is that you still need an employer to support your initial application. You need to have a job offer. But the work permit that you get, if you're approved, isn't employer specific. It is occupation specific. So it only allows you to work as a caregiver. But if things don't work out with that initial employer, you could move without having to change your work permit to another employer as an in-home caregiver. So that's a big change. And the other change is it's now a permanent residence application from the start. So at the time that you apply as a caregiver, you need to prove that you meet all the requirements to qualify for permanent residence. And those are, you need to have the equivalent of a 1-year post-secondary education credential. It doesn't need to be in Canada, but you need to go through the process to prove that it's equivalent to a 1-year post-secondary educational credential in Canada. And then the other one is a minimum language threshold. Again, by taking one of these standardized English or French language tests, the standard is lower than what you need for the programs I was talking about earlier, but you do need to prove that you have sort of basic conversational abilities in English or French. So those are the threshold criteria. If you don't have those at the time you apply, you will not be given a work permit. And again, the intent of that is to make sure that the people we're actually bringing here have a chance of qualifying for permanent residence and aren't ending up in this situation where they've been here for years and have no program that applies to them. So this all sounded pretty good in theory, but there's pretty big problems with this program. One of them is that, so you still need the employer to support your application, but now that employers are aware, well, this person could come here and as soon as they get here, they could leave my family and go to another one. You know, it's a lot of work for employers to support an application, and I think it minimizes the incentive to do that if you're not 100% sure that the person who comes is going to be tied to working for you. So I think that's disincentivized employers from supporting applications under this program. Another problem is, you know, the threshold criteria don't sound like a lot, but it's really minimized the number of people who qualify to come here as caregivers. It's not the most lucrative work, right? So if you have some post-secondary education and great English skills, you know, maybe this isn't what you're looking to do, and the people who are looking to come here as caregivers have a really hard time qualifying. And I think the biggest problem is how long it takes. So it's taking, from the time you submit an application, upwards of a year to get that initial work permit. And that's a huge problem, because if an employer is looking for a caregiver, Jamie, you and I know, like you need that person now. By the time you're thinking about this, you've got little kids who need care, or you have, you know, your elderly relative who is suddenly ill, and you can't wait a year for the caregiver to get here. So that's been a huge problem. We're not seeing high numbers under this program. I think that's the first thing they need to tackle, is doing something about the processing times for this to actually work effectively going forward. And another feature of this program I forgot to mention is that at the time the caregiver is approved for their initial work permit, they can now bring their families to Canada. So if they have a spouse, the spouse can obtain an open work permit to join them in Canada, and any kids can come with study permits or visitor records. So you need to have 2 years of Canadian work experience to transition to permanent residence. But during that 2-year period, your family can be here. So I can appreciate, you know, the sort of policy objectives behind this program and the way that it was intended to put power back in the hands of the caregivers who are coming. But in practice, it's been quite ineffective and disappointing so far. And there really is need in Canada for caregivers. I've done a fair bit of this work, and it is tough to find somebody locally who will, you know, especially if you're working kind of erratic hours and daycare isn't an option for you. This program really matters, and especially with our aging population on the elder care side, it's an important one. But the clients who have approached me about it, I tell them about what the program looks like right now, and it's just not attractive at all.
Yeah, and do you foresee, just your opinion on these pilots just turning into more permanent streams, or do you think the government has taken a sort of reflective look on this and will expect further changes to the program?
Yeah, I do think the government recognizes that having a caregiver program is important. So I don't think it's ever totally going away. But I think they're going to quickly see that the numbers have dwindled under the current program and they need to do something about it. I really think tackling the processing time is number one. That would make a big difference, and the other issues with it, that would still exist, but at least they'd get some applications. If it only took a month or two to get a work permit, then employers are going to be more interested in it. But I think the other one is these eligibility criteria. The demand has gone down on the caregiver side. And I think they need to do something to even it out with the demand on the employer side. So I expect some changes will be made. It's not a priority right now with lots of other issues during COVID, but I expect in the next year or two we may see something similar, but a little bit different than what they have in place now.
Thank you, Jackie. So let's shift gears now to talk about express entry. And I wondered if you could tell us, for those of us that are not alive to how this system works, about how does it figure into the selection of immigrants in the economic class? I think a lot of people misunderstand that express entry is not exactly an economic class or program itself, but rather a selection system. And if you could talk about that and how it intersects with some of the programs that you just spoke about.
Mm-hmm. Sure. So I think a bit of a history is helpful in understanding it. So it used to be that if you qualified under the Federal Skilled Worker Program or the Canadian Experience class, you check, do I meet the basic eligibility criteria? If the answer to that is yes, you would put together a paper application with lots of application forms and supporting documents, and you would mail that off to an IRCC office. And it would sit for a very long time, but eventually once they opened it and looked at it, if you did prove that you met all the eligibility criteria for the program, you would become a permanent resident through that program. So anyone who met the requirements, that was enough to come. The problem was the processing times became out of control, ridiculous. So particularly under federal skilled worker, it was up to something like 7 years. So you can imagine, young people who are looking to start a new life in a new country, that's a really long time to have to wait, and it just wasn't effective. And same thing for the Canadian Experience class, always moved significantly faster. It was something like a year. But still, the government decided that something had to give. They needed to do something about the processing times continually creeping up. So express entry is a system. We adopted it from other countries that have used it. UK, Australia, New Zealand, I believe, are the ones we sort of adopted this model from. And it's an application intake system. So you're right, Jamie, that's I'm often explaining to clients that the category they're applying under is not express entry. That's just the means by which they're applying to one of our other immigration categories. So Federal Skilled Worker Program, Canadian Experience class, and some provincial applications now live within express entry. So you need to meet the basic criteria for one of those programs, but then you also need to put your name into this express entry system. So it's another points-based system. And it's all done online. That's another big shift. So everything in immigration world used to be on paper, and now it's, at least for the express entry applications, it's 100% online. So let's say, you meet the criteria for federal skilled worker program. What do you do next? Well, you upload a profile into the express entry database, and it's going to prompt you for information like your age, your language scores, your highest level of education. If you have a spouse, then your spouse's level of education and work experience are also relevant. So, you'll be providing their language scores and information as well. And yeah, so the point system under express entry is called the comprehensive ranking system. And based on the answers that you give to all the questions they ask, it's going to spit out a number for you under the comprehensive ranking system. So it's important to know that, if you're applying as a federal skilled worker, there's 2 point systems now. There's the original point system to determine if you qualify for the federal skilled worker program, but then there's now also the comprehensive ranking system. And so when you upload a profile under express entry, you end up in a pool of candidates who are sitting there hoping to get an invitation to apply for permanent residence to Canada. My understanding is right now there's well over 50,000 people who are sitting in that pool hoping to be invited. And this is the big difference. Everybody in that pool meets the minimum criteria for one of these programs. Otherwise, they wouldn't be able to upload their profile. But a significant number of people in that pool will never get an invitation because their point score is too low. So that's the key now, is you need to be competitive. It's now a competitive system. This has worked really well for the government because they can turn the tap on and off. They can decide how many people are being invited today under express entry, and that number can be lower than it was last week, right? They can decide on any given day how many people we need, how we're doing with our backlog. If we're starting to get a little bit of a backlog of applications, we can turn the tap off and not invite anybody new for a little while. And if we're about to hit our numbers for our immigration levels for the year, then we'll just make the points total that you need to get an invitation higher, and fewer people will get invited. In some ways, express entry has been great. It has kept processing times down to under a year. They do fluctuate. The standard that the government says they try to meet is 6 months. At most times, in most cases, that's actually true. But with COVID right now, and there's been some other periods of backlog, it can be up to a year. But the processing times have changed significantly. So if you're lucky enough to qualify, if you're not lucky enough to be able to achieve a points total that's high enough, express entry is really fantastic, and it gets you to Canada quickly.
Thanks, Jackie. I've heard you in the past refer to the express entry system as a dating matching system. And I wondered if you could talk about, just like any matching system, what are its benefits, what has been the challenges in using this system from the perspective of a lawyer and the client, and how the government has responded to many of these challenges.
Yeah, I describe it to clients that way a lot because I think it's a way that we can understand it easily. But basically now it's, you put your name forward to say you want Canada, but Canada also needs to want you. So it's this matching type system where both parties need to be on the same page and match. So I think the benefit for clients is, again, if you're someone who is young with a high level of education and good work experience and excellent English, then you're going to be a prime candidate under this comprehensive ranking system, and you should get an invitation quickly, and then within 6 months you're a permanent resident of Canada. But for people who don't fit that profile, it's been a real disadvantage. So an example that I see all the time is with older applicants. So many of whom have, excellent English, high levels of work experience and education, but it's a really unrelenting program when it comes to age, because under this comprehensive ranking system, you're getting upwards of 110 points if you're in your 20s, and then by the time you hit age 45, you're down to 0. So I find that a lot. Really high skilled people who have job offers in Canada, who have employers who want to keep them, but they happen to be older. It can be impossible to qualify now. Another example is students. So students who have come to Canada and, they've been recruited by institutions that promise that if you get a degree with us, that's going to be a route to permanent residence in Canada. So they've come with the intent of staying. They've studied for 2, 3, 4 years in Canada. They've gotten a postgraduate work permit. But, maybe they struggle to find a skilled position, especially entry-level jobs for students. Those can be hard to come across. Or their language skills are good, but not the very top levels on these standardized tests. Those people are struggling, and they didn't realize that they would struggle to qualify for permanent residence. So I think that's a big problem, is there's a fair bit of misinformation, and it's not always malicious. These schools are now learning that, okay, things aren't the way they used to be, and we can't be telling people that they have a sure bet to permanent residence, because that's no longer the case. So we're seeing these kinds of issues come up where people who would have qualified under the old system are now out of luck under express entry. The other thing that's hard from a lawyer's perspective is giving people advice, because we can do our basic calculation and let people know, okay, this would be your score under the comprehensive ranking system. Here's 2 years of examples of the scores that you need to qualify, but they shift all the time. So they've been the way things had been going is, before COVID, the scores had been trending up pretty rapidly for several years. And I think that was just a result of more people being interested in entering the system. So that made it more competitive. So, someone who had a 430 in 2017, we would have told them that's a really great shot. But a 430 now, maybe not. So it's, obviously clients want certainty, and we can't give 100% certainty with this new system. If your score is 300, then I can give you 100% certainty you're going to sit in that pool and never get selected. But if you're sort of on the cusp, I find it that's a real challenge, is giving advice on whether this is worth pursuing, or whether you want to be exploring other options, or whether Canada is just a no-go for you.
That's fascinating, Jackie. Thank you for sharing that insight. I wondered now if you could maybe, as a final question, just talk about what are some of the things that we should look out for, and especially if there's any challenges that you've seen with your clients during the pandemic. I imagine that processing of applications has been put on the back burner largely, or been slowed to some extent given the situation that we're in. But I wondered if you could talk about that, and also what we can look forward to, what you think might change, or what we're waiting for the government to comment on or design in the next couple years.
Mm-hmm. Yeah, the pandemic's been an interesting time. I think what we expected was for processing times to go way up, and that's been true under some programs. But it's been interesting seeing how the government has adjusted. So one thing that they did back in March when this first hit was they decided to prioritize applicants who are already in Canada. thinking, they're here. Others who are outside of Canada can't travel here right now, so let's transition people who are here to permanent residence. So the express entry system used to they used to do draws for both the federal skilled worker and CEC at the same time. And when March hit, all of the draws were only for candidates who qualified under the Canadian Experience class. So an interesting development, because the scores for the CEC started dropping, and we had many happy clients who didn't think they'd get an invitation who did. And then many unhappy clients overseas who thought they were a couple weeks away from moving forward with their PR application, and suddenly it dried up completely. So there's been things like that have come up that we've had to adjust to. In terms of what we can expect going forward, I mean, express entry is here to stay. The government's very happy with how that program works. I think we're going to see more and more programs moving online. The express entry sort of started that. Some of the provincial programs are now slowly starting to move things online, slowly, and with hiccups along the way. That's another thing I didn't expect about being an immigration lawyer, is the amount of technical frustration I need to deal with, because you're working with these applicant portals all the time, which can be glitchy, especially as they're first starting out. Express entry's gotten a lot better, but in the first few years it was horrible to deal with, and spend time watching wheels turn on your screen and clicking, and anyway. We've talked about the Caregiver Program. I think that's one to watch, how it adjusts. And then there's also some interesting new pilots aimed at targeting lower skilled workers. The Atlantic Immigration Pilot is one of them. So that's a new program that's targeting people working in fisheries and meatpacking, and intending to have a route for permanent residence for those people, because most low-skilled workers do not have any route to permanent residence. So I think we're starting to see some recognition that that shouldn't be the case, and that we want to keep people here who have been working hard, and we need workers in those industries. So I expect some more pilot programs in those areas to keep popping up and maybe be made permanent.
Yeah, and finally, I just wanted to ask if you could comment on, you have worked, I think, both in the paper and the online system, but do you think, working through online applications, that takes away from the discretionary decision-making that has taken place in the past? Is it, increased desire for automation, for using systems that streamline decision-making and relying more on algorithms or AI perhaps in the future? But I wonder if there's still a place for discretionary decision-making. We still see a lot of discretion in other parts of immigration law and immigration system, but this is one area where it's becoming less possible to ask for a decision maker to use their discretion. What do you think of that? Is there, a tension between the processing, the quicker processing, the faster response times, versus, perhaps there is reason to accept an application that might not meet the criteria that you spoke about?
Yeah, I definitely think it is a tension. It used to be the case, for example, if someone qualified under federal skilled worker, but what's an example, that maybe their points total was 65 and not 67, but there was a really compelling reason why they couldn't hit 67, but why they should still be an excellent candidate. You could submit that application. There was no guarantee that it would go through, but you could ask for exceptional consideration and make submissions on that point. Now, if you don't have a 67, you can't get into the pool. There's nobody to make that discretionary argument to, because you need to get past the computer bouncer before you ever file an application. So you're right that asking for any kind of discretionary consideration is impossible in some cases now. I've had a couple clients who wanted me to make that kind of argument, and figuring out how to get it in front of a decision maker, that was the biggest hurdle, and eventually came to the conclusion that it wasn't really possible. If you get to the point of having an invitation to apply through Express Entry, and then you're submitting a full permanent residence application, then you can make some submissions at that point. But you need to get through the door. And yeah, I agree. I think there's lots of benefits to this kind of streamlining, but there's people who are being left behind who I don't think we always want to be left behind. So it's been interesting for me in the last couple of years. I do a lot of humanitarian and compassionate applications as well, and I'm finding I'm doing more and more of those H&C applications for people who 5 years ago would have qualified as an economic immigrant, but now they're out of luck, but there's really good reason for them to stay in Canada. So we're going that humanitarian route. And I think, the federal government's going to realize they're seeing more and more of those. And maybe that'll trigger some change. I don't know. But it's, sort of an unforeseen development.
That's great, Jackie. Thank you so much for sharing your thoughts on that. And thank you for taking the time to make all of this very digestible for those of us who do not practice in this area, and for the students who, I think, when at an initial glance at anything written about this, or the regulations, the legislation, all the material you talked about in terms of where you find information, I think it's a very daunting area to enter into. But I think you've made it very easy to understand in this episode. And I agree with you that there is a lot to keep our eyes on in the future, and it'll be interesting to see the tweaks, the major program changes that are going to inevitably come as we proceed through this post-pandemic, hopefully.
Mm-hmm. Thanks for having me, Jamie. That was fun.
Migration Conversations is created and hosted by me, Professor Jamie Liu, and produced by University of Ottawa Tech Law Fellow June Gleed. This podcast was made possible with the guidance and assistance of University of Ottawa Tech Law Fellow Ritesh Kotak, Carleton University graduate student Rachel McNally, as well as the generous support of Carleton University and the University of Ottawa shared online projects and initiatives. You can find more Migration Conversations episodes on Apple Podcasts, Spotify, Google Podcasts, and YouTube with closed captions. Thank you for listening, and a special thank you for all the guests who have shared their experiences publicly.